Hi, all. I'm going to give everyone about a minute or two to come on. And then once everyone gets settled, we'll go ahead and begin. All right, so we're going to go ahead and get started. Hello, all. Welcome everyone to today's webinar celebrating 30 years of VAWA, understanding VAWA and leveraging it to support survivors, hosted by JWI's National Alliance Collaborative and Here for You. My name is Anna Gerstein, Program Manager at Jewish Women International, and I have the privilege of moderating today's discussion. Thank you for taking the time to join us, and a special thanks to our incredible panelists for sharing their expertise with us this afternoon. Before we begin, please remember that this is not a confidential space. If you are a victim or survivor in need of support, we encourage you to reach out to the National Domestic Violence Hotline at 800-799-7233 or connect with the local domestic violence program in your area. We will also share the links to these resources in the chat. Today's webinar will be recorded and posted online. We will be discussing topics today that might be difficult for some participants. We encourage you to please take a break if you need it. Now, without further ado, time to introduce today's incredible panelists. Rachel Graber is the Vice President of Government Relations and Advocacy at Jewish Women International, where she advocates for survivors and advances key legislation. She has helped pass critical laws, including the 2022 Violence Against Women Act, the Bipartisan Safer Communities Act, and the VOCA Fix Act. Christina Velez is the Legal and Policy Director of Astesta Immigrant Assistance, and a national organization that supports non-citizen survivors of gender-based violence through training, technical assistance, and policy leadership. She has represented immigrant survivors in various capacities throughout her career and previously directed the immigration units at the Queens Legal Services and the HIV Law Project in New York. DFOX has over 30 years of experience in the domestic violence and sexual violence movement, specializing in fundraising, organizational development, and survivor housing and economic justice. As Deputy Director of Housing Policy and Practice at the National Network to End Domestic Violence, they advocate for expanded federal housing protections and the NNEDV collaborative approaches to housing for survivors, enhancing access to safe, affordable housing, and she is also an expert on gender-based violence and homelessness. Kate Waltz is the Director of Litigation and National Housing Law Project and leads the law project's gender-based violence work. Kate was on the drafting team for the 2013 and 2022 VAWA reauthorizations and provides technical assistance and advocacy to survivors, advocates, and victim service providers on the VAWA and effective VAWA implementation. Lastly, we have Tiara Williams, who serves as the VSTOP and Virginia Sexual and Domestic Violence Victim Fund Grant Program Coordinator at the Virginia Department of Criminal Justice Services. She is responsible for engaging in the grant program coordination for the VSTOP and VSDVVF grant programs, as well as providing training, technical assistance, and ensuring adequate grant-sponsored service delivery. We are so thrilled to have such an esteemed group of experts here with us today. Their deep knowledge and commitment to survivor support will make a compelling and insightful discussion as we celebrate 30 years of VAWA. Please use the Q&A box for any questions you have for our panelists, and we'll do our best to address them during the latter as part of the webinar, time permitting. Remember, do not share confidential information, as all attendees will be able to see your comments. Additionally, at the end of the presentation, we will provide email addresses of each of our panelists for further follow-up if you have any additional questions. Now let's get started with our first presenter. Rachel, the floor is yours.
Thanks so much, Anna. And thank you also to everyone who has joined us today to celebrate 30 years of the Violence Against Women Act, also known by its acronym of VAWA. So I'm going to give a very brief VAWA overview and try to get through it very quickly because we have so much amazing content from such knowledgeable speakers who are going to dig more deeply into certain areas of the law. So next slide, please. Next slide, please. There we go. Thank you. Awesome. So VAWA was passed originally back in 1994 as part of the Omnibus Crime Bill, which bill has a very mixed legacy. The crime bill, with its heavy emphasis on policing and punishment as the primary solution to violent crime, led to mass incarceration, particularly of Black and brown men, which has torn communities apart and criminalized generations of young people by expanding the school-to-prison pipeline. But riding along with the omnibus crime bill was VAWA. So we're going to dig a bit into VAWA, into what's in it, into what has done, and then talk about some specific ways that VAWA can help all of our attendees serve victims and survivors. So it has been reauthorized 4 times in 2000, 2005, 2013, most recently in 2022. I think people sometimes ask, why do we have to reauthorize VAWA? And that's just kind of how most federal grant programs work. Congress wants to go back to them periodically and make sure that they are working as intended. They want to say, okay, well, what's working, what's not, what needs to be improved, what changes do we need to make so that the law is, and the funding that we're putting out to support the bill is actually having its intended effect. Next slide, please. So while VAWA's legacy, the crime bill's legacy is complicated, VAWA's legacy is also complicated in ways because parts of the law were based on the premise that we can incarcerate our way out of gender-based violence. But that being said, VAWA's legacy has also been to bring survivors of domestic violence, sexual assault, stalking, and later dating violence as well out of the shadows. So before VAWA, domestic violence was a private family matter. If there was a law enforcement response, that usually involved just telling the perpetrator to take a walk around the block to cool off. Sexual assault was similarly discounted, with blame being placed on the victim, and with a focus on sexual violence committed by strangers, when of course, we now know that most sexual violence is committed by someone with whom the victim is acquainted. To be clear, VAWA has not totally solved that, but we have made great strides because of VAWA's focus on bringing this out of the shadows. So VAWA began to change how we as a nation viewed and responded to gender-based violence. So, instead of a private matter of which the victim should be ashamed, gender-based violence became an all of us problem, right? A societal problem. And VAWA brought together different stakeholders, including victim services, law enforcement, prosecutors, and courts, among others, to provide a coordinated community response to the 4 VAWA areas of domestic violence, sexual assault, dating violence, and stalking. So, over the years, VAWA has recognized that survivors are not a monolith, and survivors need responses tailored to their specific circumstances. So VAWA established a host of training and technical assistance opportunities to improve victim services, legal systems responses, and responses by other systems and stakeholders to gender-based violence. It has highlighted the unique needs of different communities, including underserved communities and culturally specific communities. It provides a pathway to safety and a status for undocumented immigrants facing gender-based violence, which Christina will explore. VAWA affirmed the inherent authority of tribes to hold non-native perpetrators who prey on native people on tribal lands accountable. It prohibits discrimination against victims and survivors based on sexual orientation or gender identity. It invests in prevention. And it addresses the holistic needs of victims and survivors, including their housing needs, which Dee Fox and Kate will discuss. So basically, VAWA is a full system response to gender-based violence. Again, that's that coordinated community response. Next slide, please. So one of the primary ways VAWA has done all of the things I just talked about is by establishing important grant programs. So some grant programs are formula grants where every state gets a certain amount based on population, and then the state distributes the money to local stakeholders. And Tiara will dig into the biggest of these formula grant programs, which is STOP, including talking about how to access funding. Some grant programs are discretionary grants, and grantees apply directly to the federal government. So most VAWA grants are administered by the Department of Justice, the Office on Violence Against Women, but there are grants in other federal agencies too. So you'll see on the slide a list of some of the grant programs administered by the Office on Violence Against Women. I also added the Rape Prevention Education formula, which is a grant which is administered by Health and Human Services. But as I said, there are grant programs scattered throughout different federal agencies. As you will see from the slides, these grants are intended to ensure that all survivors have access to services that meet their specific needs, recognizing that survivors of abuse in later life might have different needs than survivors in rural communities, who might have different needs than survivors in faith communities, or survivors who are LGBTQ or are people of color. And of course, these identities are not mutually exclusive, right? These identities are often intersecting, and programs and communities must be prepared to respond to survivors as whole people, in the full beauty of who they are. So our next slide, please. The most recent VAWA reauthorization was just a few years ago in 2022. And you heard everybody talk about how we were involved in that process, in putting together that bill. So as I said, we started actually in 2016 with extensive outreach to victim service programs, to victims and survivors themselves, to experts, to other stakeholders, to identify what was working, what wasn't working, and what we needed to tweak, what we needed to update, what we needed to change, what we needed to improve. So I usually summarize the theme of VAWA 2022 as meeting survivors where they are. We know real life is messy. And theoretical conceptions of the needs of some sort of like fictional generic survivor really aren't sufficient to respond to the lived realities of like actual human beings, right? For example, VAWA was built, the original VAWA back in 1994 was built on the assumption that accountability means criminal accountability. But that's not what many victims want. And engaging with law enforcement and the legal system is neither safe nor desirable for many communities. So, this VAWA included a new restorative practices grant to explore other forms of accountability. It allows legal services for victims to help with expunging criminal records, recognizing that many criminal convictions are the result of experiencing gender-based violence. It invested heavily in prevention, includes a focus on the needs of diverse communities. The bill was a couple 100 pages long. So I'm not going to summarize it all for you, but if you follow the QR code, you can find a 2-page summary of the highlights. And let me tell you, whittling it down to 2 pages was a challenge, but we got there. So next slide, please. So I know I don't need to tell you all this, but VAWA makes a huge impact in the lives of victims and survivors, and also the advocates and other professionals who serve them. So the Office on Violence Against Women, they publish a really excellent periodic report about the impact of VAWA, and I would definitely encourage everyone to take a look. I pulled a few numbers from the most recent report so you can see what some of what VAWA funding supports. These are just the tip of the iceberg. Like I said, I just kind of pulled a couple, but there's a whole 60-page report full of these. So in just 1 year, please go back up. Thank you. In just 1 year, VAWA funded programs served 4 million victims, or provided 4 million victim services. answered 1 million hotline calls, provided 2.5 million housing bed nights, obtained 350,000 protective orders, trained hundreds of thousands of professionals in a variety of fields in how to respond appropriately to gender-based violence, and much, much more. Urge you to check out the OVW website. It's got a lot of great information. Okay, awesome. So before I turn it over to our next speaker, I just want to go back really briefly to the idea of training and technical assistance. So while originally training and technical assistance, which we often call TTA for short, was only available to VAWA grantees, VAWA 2022 also opened it up to potential grantees and other entities, although existing grantees do have priority. So we encourage you to check out the TTA opportunities available by following the QR code on this slide. It will take you to this page without the QR code, of course, on it, because I just stuck that in there for your convenience. You know, we know that you have survivors from all walks of life coming through your doors, and training and technical assistance provides the support you need to serve them as whole people addressing their unique needs. So please save that link, explore the TTA opportunities after the webinar, and after you hear what my amazing colleagues have to say. Just so you know what resources are available to you to help you then provide the most effective services possible for each person you serve. So now I will turn it over to Christina to talk about VAWA's protections for immigrant survivors. Thanks so much, everybody.
Thank you. Great, Rachel. I appreciate it. I am Christina Velez. I'm the Legal and Policy Director of ASISTA. And as Anna said, we are a national advocacy organization working at the intersection of immigration and gender-based violence. And we are also a TTA provider through OVW. So please also look for us there. ASISTA is also one of the 4 co-chairs of the Alliance for Immigrant Survivors, which acts as a hub for immigration policy for the National Task Force Against Domestic and Sexual Violence. And in addition to acting as its immigration committee, the Alliance hosts a monthly policy working group call, as well as other discussions to discuss advocacy for immigrant survivors. Our Alliance website is www.immigrantsurvivors.org. I'll plug this into the Q&A at some point during the presentation. But thank you all for making space for us to join you here today. So as noted, I'm here to review the immigration relief provisions included in VAWA and its related legislation and policy developments over the last few decades. To start with, this timeline shows the development of VAWA immigration protections. It covers pre-VAWA protections for abused spouses who faced a loss of status, immigration status, while going through the green card process. And it also covers the creation of special immigrant juvenile status, which we're actually not going to really get into today, but which continues to be a source of protection for abused children without immigration status. This timeline goes through the passage of VAWA in 1994 to the creation of UNT visas in 2000, the extension of confidentiality protections to immigrants covered by VAWA, which I think actually happened in 2000 also, and various reauthorizations up to 2022, when some minor but helpful policy changes were added. We've also included on this timeline the passage of an immigration law with the acronym IRA in 1996, because that law very sharply curtailed immigration options for many people, making these VAWA pathways all the more crucial for non-citizen victims of crime and gender-based violence to find safety and security in the United States. Let's go to the next slide. Thanks. This slide shows the immigration and DV power and control wheel that was very helpfully adapted by Futures Without Violence and is in use by USCIS in their training of new adjudicators who are charged with working on these kinds of cases. This wheel is intended to show the ways that immigration status and vulnerability to immigration enforcement are weaponized by abusers to coerce and control their non-citizen partners or family members. These forms of coercion are intertwined with others that DV advocates may be more familiar with outside of the immigration context. And these also include the use of national origin or race-based disparagement as means of control and coercion. So as we've seen over the years, I also want to note that increases in arbitrary immigration enforcement have bolstered these threats by abusers to cause deportations of their partners and their partners' children. So even if you're not working with the immigration provisions of VAWA, I think it's very useful to familiarize yourself with these wheels, this wheel in particular, and the various ways that abuse shows up, especially in mixed status households where the abuser is a US citizen and the abused spouse or other family members are not. So some of these immigration-specific abuse dynamics include withdrawing or threatening to withdraw immigration papers that were filed for residency, forcing or coercing victims to do something that jeopardizes their status, threatening to call ICE to get victims arrested and deported, telling them that the police will arrest them because they are undocumented if they call the police for help. Another thing we often see is the hiding or destroying of important paperwork that's needed for immigration status applications, as well as threats to family members both in the United States and abroad. So let's go to the next slide. We're going to look very briefly at all of these immigration status remedies that VAWA has made possible for survivors, starting with VAWA self-petitions, which really remarkably countered these forms of coercion that we covered in the wheel. The aim is to neutralize the power of an abusing spouse or parent to control the immigration process. Let's go to the next slide. Right. So on this slide, you can see the benefits and requirements of VAWA self-petitions. The VAWA self-petition turned the family-based petition process on its head. You all might be familiar with the so-called green card marriage, in which a foreign national marries a US citizen and then submits an application and attends an interview where they can answer questions about their lives together. An abusive spouse can tank this process at multiple points. They can refuse to sign the paperwork required to begin the process. They can put it off indefinitely. They can refuse to show up for the interview or behave so badly at the interview that the case is denied, leaving the abused non-citizen spouse even more isolated and without immigration status. So this petition process allows an abused spouse or child of a US citizen or green card holder to apply for the same kind of visa without needing to involve the abusive party at all. They don't even need to be informed about it, and they should not be informed about it by any government actor. The VAWA self-petitioners are not required to move out of the house with their abuser or obtain a divorce to access relief. VAWA allows them to submit the best kind of evidence that they have, including their own testimony, as proof of all of these requirements. And VAWA self-petitions were created in 1994 and remain one of the most valuable pathways to safety for abused immigrants. And the program is very successful, so much so that there is now a backlog of about 40 months for adjudication. So although I will say that it's notable that the Immigration Service provides notices to those with pending cases to make them eligible for certain benefits, which I think we'll see a little bit more about later on. Let's go to the next slide. VAWA cancellation of removal. VAWA also created this waiver. It's a type of waiver that we call VAWA cancellation that can only be applied for by someone in removal proceedings. It's a bit more flexible than other kinds of waivers in removal proceedings, which is a whole nother very complicated topic. But it's important to know that there is VAWA specific relief available to abused non-citizens who are married to US citizens or green card holders, or in some cases who are unmarried partners who have children who are abused by US citizens or green card holders. In this particular form of relief, that is an avenue that's open for applicants, which it is not for VAWA self-petitions. So VAWA cancellation of removal is a little bit broader than the VAWA self-petition process, but again, it's only available to people who are fighting their removal from the United States in immigration court. Let's go to the next slide. Thanks. So this is the pre-VAWA immigration pathway, the conditional residence waiver that we saw in the timeline, and it's still available. It applies to folks who have already gone through the first part of the green card marriage process. I'm using the term green card marriage, but I don't really mean green card marriage as in fraud. I mean green card marriage as in the specific mechanism used by people who are married to US citizens to apply for green cards based on their marriage. So it applies to folks who have gone through the first part of that process, but need to do one last thing to obtain a permanent green card, which is the application showing that the marriage is still viable after 2 years, and it's an application that both spouses need to sign and submit to the Immigration Service. So in abusive marriages, of course, this becomes a huge flashpoint, such that the US citizen spouse who is intent on controlling their partners often refuses to participate, leaving their spouse with expired status, loss of work authorization, feeling very vulnerable to removal proceedings, very often being placed in removal proceedings at the conclusion of their conditional residency period. So very scary to be at this final stage and have to navigate it with an uncooperative spouse. So this is the waiver of the joint filing requirement and allows the abused spouse to file on their own with evidence of abuse or divorce and keep their green card. Go to the next slide. This is a more recent innovation, the 765B. We're jumping around a little bit, but definitely wanted to cover it here. This allows abused spouses of non-citizen visa holders. So typically people who have work-based visas that are temporary, but can last for many, many years. This allows their spouses who are abused to apply for their own work authorization and also obtain notices making them eligible for certain public benefits for survivors. I want to note here that our buddies at Raksha and the South Asian Bar Associations advocated really hard for this because they were seeing a lot of abused spouses in their community who were not eligible for other protections under VAWA because of the type of immigration status that they had. So this was added to VAWA in 2005, but it took until 2017 for regulations implementing it to be issued. Thanks again to those concerted efforts of community leaders, but we want to see more people making use of it where it's available. So here it is. Let's go to the next slide. Thanks. All right, here we are, U visas. So I'm going to go pretty quickly, I think, through U visas and T visas. I think we're probably a little short of time. And I also think that if you're a non-lawyer, it's really important to know that these exist and that these are available for people that you're working with. And if you are a lawyer, you should get in touch with us to learn more about them if you'd like to. Again, we are a TTA provider. We've also provided edits to the Women's Law website that has some more plain language descriptions of all these forms of relief. And we helped to edit it this past year, so you can check that out for more as well. But U visas were created by the Victims of Trafficking and Violence Protection Act in 2000, and regs were finally issued 7 years later. So these protections were amended to the VAWA Act itself in 2013, I believe. U visas were developed to meet a gap in coverage, again, presented by VAWA self-petitions and forms of relief that were based on marriage to a US citizen or green card holder. So the U visa program recognizes that many non-citizen victims of abuse and crime are fearful of coming forward because they are vulnerable to deportation, even if they're not connected in any way to US citizens or green card holders. So the U visa program established these protections for non-citizen victims who report crimes against them in order to both support them and encourage cooperation with law enforcement agencies. As part of this program, a non-citizen victim is required to obtain a signed certification from a law enforcement agency, a requirement which sometimes presents a barrier to immigrant victims who are living in places with less law enforcement cooperation. with this VAWA program and who are living perhaps in places with a lot of state and local level anti-immigration policies, or where that's a part of the culture in the place that they're living. Nevertheless, this program has spawned an enormous amount of advocacy and guidance to implement it across the country. It's been very successful, not only for survivors of DV and sexual assault, but also for undocumented immigrants who've suffered assaults or hate crimes and labor exploitation as well, that are covered also by the U visa program. Let's go to the next slide. So, as you can see from this slide, the benefits of a U visa include work authorization and a pathway to citizenship for the victim and their family members. Because of the very long 15-year backlog for final adjudications, which we'll talk about in a couple of slides more, the Immigration Service has set up a wait list and an interim relief protocol for applicants to get a work permit and protection from deportation in increments of 4 years if they have filed a bona fide or meritorious application and are deserving of a positive exercise of discretion. There's currently a 5-year wait for most of these bona fide determinations, and we are working closely with our partners to try and reduce that through our advocacy with Congress when every appropriations season. Let's go to the next slide, please. Continued presence is another form of protection from deportation that also provides work authorization for non-citizens who are identified by law enforcement as survivors of a severe form of trafficking. You can see that term of art is quoted on this slide. That's something that is also worthy of a whole separate hour of discussion. But just note that that means different things depending on the circumstances. For some, though, this continued presence remedy is the first step for applying for a U visa. For others, other applicants may go straight to the U visa process, and still others may find this useful in order to access benefits and support services before they return to their countries of origin. So the decision of whether to seek continued presence is one that we urge people to make with their clients or with their advocates, because there is a very close involvement of law enforcement in these requests. Let's go to the next slide. Here we are at TEAS, and which I mentioned earlier, and which came about at the same time as the U visa program. You can see on the slide here these requirements for a T visa, with the important terms of art again bolded on this slide. This slide is bolded, last slide is in quotes. But like U visas, T visas provide a pathway to citizenship for survivors and their family members. We'll see the differences in processing times and available numbers for all of these forms of relief on the next slide. I want to encourage everyone to think about a T visa as being potentially more available than you think. What is meant by severe form of trafficking, like I said, it's really very context dependent, and we urge you to get in touch and look at the other resources that I mentioned if you'd like to learn more. Let's go to the next slide. Processing times. This is a very important part of any discussion of the immigration relief remedies included in VAWA and related legislation. I want to cover these a little bit because I think they really feed into the amount of work that it takes to help survivors through these processes, right? Because they involve representation over a lengthy period of time. So for VAWA self-petitions, there is no visa cap. Folks who are married to U.S. citizens who are applying for protection under the self-petition remedy can have their green cards immediately upon adjudication. but it's currently taking about 39.5 months for adjudication to happen, for final adjudication. For VAWA cancellation, there is a 4,000, it's not really a visa, but there's a cap of 4,000 on the number of grants of any kind of cancellation. This means also cancellation of removal, which is another form of relief and removal proceedings. Right now, there's about a 3 to 4 year wait. If a person is in detention, however, in immigration detention and applying for this, they can be granted immediately. For U visas, I feel like a lot of folks who are somewhat familiar with these remedies understand or have heard that there is a huge backlog. That's in part because of this 10,000 visa cap. 10,000 visas, U visas per year can be issued by the United States Citizenship and Immigration Services. And there are currently over 100,000 pending. Even more if we include family members, but family members are not included in the visa cap. But there is, as I said, a 5-year wait for a bona fide determination, anywhere from 10 to 20 years wait for final adjudication, which puts them on the pathway to citizenship. P visas, 5,000 visa cap that remarkably has not yet been met, but we expect it to be this fiscal year. Currently around, I think, an 18-month wait for final adjudication of a T visa. And continued presence, no cap, but it can be issued in a matter of months if a law enforcement agency deems the person to be eligible for it. Again, it has to go through law enforcement, and there's a lot of contact with law enforcement that's expected in those applications. So all of this really informs a lot of the advocacy that we take on the policy level. You know, we're pushing for more appropriations for adjudications, and statutorily, we'd love to see these caps lifted. For non-lawyers, you know, a lot of times we get asked like, well, these are so technical and complicated. So what can we do to help survivors who are eligible for these forms of relief? Some tips included a hotline there that you can use to find out if someone is in removal proceedings. You need their alien number, so-called alien number. It's an A number, which most people who are in removal proceedings will have. You can help survivors gather needed documents. As we talked about earlier, abusers will very often take control of those documents. So anytime they become available, you can agree to hold or copy them for survivors. You can refer them to reputable immigration representation. You can work with them as a team during the preparation of these applications as much as possible. And you can help them with safety planning. Once folks start applying for these forms of relief or start taking steps to be free of abusive situations, you know, as we all know, I think sometimes that as well becomes a flashpoint. So safety planning is going to be an important step for them, along with reaching out for status-based relief, immigration status-based relief. So I think that's it. That's all I have. I think the next slide has my contact information. Yes, we have some information about how you can access ASISTA and OVW-TTA. And now I'm going to pass it on to our colleagues, Kate Wilson, DeFox. Thank you very much.
Hey everybody, we're having a few technical difficulties with our sound. We'll be right with you. Sorry about that.
All right, thank you, everybody. Sorry, there was a second there. I was having a sound related issue. We're going to go ahead and get going. I am Dee Fox, pronouns she, her, they, them, and I work with the National Network to End Domestic Violence. I'm co-presenting with Kate Walls from the National Housing Law Project. So we're going to get going because we have a lot to cover, as you all know, on DV housing and DVSA housing and VAWA housing protections. So to get started, I just wanted to let you know that we are part of a larger organization and network of a whole host of technical assistance providers that are part of the DV Housing and Technical Assistance Consortium. That's what we were previously called. Now we are the Safe Housing Partnerships Technical Assistance Consortium. So you can see all of the acronyms there and all the partners that we work with at federal agencies to make this work. I do want to highlight really quickly that we also now have sexual violence. There's a National Sexual Assault and Housing Collaborative with a bunch of different partners that are doing great work at the intersection of SA and housing. And we also wanted to highlight and elevate that there is a STARS, National Indigenous Safe Housing Center, that's doing a lot of work with tribal communities and Native American communities at the intersection of domestic and sexual violence and housing. So we're part of this work, the Safe Housing Partnerships work, and the Safe Housing Technical Assistance Consortium. And so I wanted to go a little bit deeper. Next slide, please. I wanted to go a little bit deeper, like some of the things that we want to think about when we're talking about VAWA housing rights is there are special considerations for survivors and survivors of domestic and sexual violence. So people have a whole host of mitigating factors that happen for them as survivors. And I know it was described earlier that, you know, people have many things happening in their lives that are impacting their abilities to get safe and stable housing. So with DV survivors, they often have negative impact and consequences as it relates to their harm doers. So I have to talk about in the housing field and the homelessness field that survivors are not only trying to get safe and stable housing, but they also typically have somebody who's actively trying to harm them and ruin their life. And in addition to that, when survivors are experiencing homelessness or fleeing or attempting to flee sexual domestic violence, they are often perpetrated also by people in the community. If they're living outside or experiencing homelessness, there's often very serious dangers of being outside or being in unstable or housing unstable situation that makes survivors of sexual and domestic violence very, very vulnerable. So just a little bit of sexual violence in housing. That can happen anywhere, anytime. And it is often there's situations in housing where harm is caused because people have power over you in a housing or a survivor situation or a landlord situation. And so there's often instability that's caused by these power imbalances. And there's often a lot of instability and houselessness that happens as a result of sexual violence. And there's really additional needs and additional protections to protect survivors, especially survivors of sexual violence, if they are experiencing homelessness outside or in a very vulnerable, unstable housing situations. Next slide, please. We want to do a quick overview of VAWA and what we're looking at in terms of the protections. We're celebrating the 30th anniversary of VAWA. I'm sure many of people on this call, like myself, can remember when VAWA was passed in 1994, but the VAWA overview around housing protections are not very, a little bit more recent. So since 2005, we have had housing protections for domestic and sexual violence survivors. So we have made sure through over the years and the new iterations of VAWA and the new passages of VAWA that we have expanded those definitions and created additional protections for domestic and sexual violence. So the most iteration, there's been additional things around considering economic and technological abuse. And there's also key protections that are very critical around how the law protects around gender and sex, gender identity, sexual orientation, and disability and age. So we're very proud of the work that we have done around VAWA and what we've done to expand the definitions and to make sure survivors are protected and to meet the needs as we hear the needs in the field increasing. Next slide, please. There are many programs that are now covered. That's a new iteration of the VAWA 2022 is there are programs that are covered that were not covered before and that are much more expansive. So as many of you all know, the housing landscape in our country is a challenge and very difficult. We have a lot of different programs, a lot of different federal agencies that offer housing, but we are proud that now these programs, all the various housing programs are covered. If you're a federally covered housing program, you receive protections as a survivor. So this is listing some of them, and then we also have a catch-all phrase that's now in the VAWA language that says if there's any new housing created or other federal housing programs that come to pass, that those will also be protected. I also like to highlight that there are protections with OVW transitional housing programming now with the Office of Violence Against Women and also in Department of Agricultural Treasury. And then obviously there's a ton of housing programs with HUD. Next slide, please. So here's it spelling out a little bit more some of the various housing streams that now VAWA does cover. So you just have that at your fingertips so you can keep that in mind. And we do have that catch-all provision language that federal programs must give notice of VAWA housing rights. With the VAWA Violence Against Women Act, housing that is federally covered, survivors should not be discriminated against as a result of them having been a survivor of domestic violence, dating violence, sexual assault, or stalking. And this includes additional adverse factors, such as things like poor credit history, or if you have a housing history that might have some dings on it, that this shouldn't impact a survivor when they're getting housing if they can make that case to a landlord. Additionally, survivors should not be evicted from housing if they are or have been a victim. So if you are currently working with a survivor that is experiencing domestic or sexual violence and they're in a potential eviction process or having issues with their landlord, this is a time where you would step in and want to support them and make sure as a result of their victimization, they are not losing their housing. So there is language around an incident of violence is neither a serious or repeated lease violation by the victim or good cause for evicting the victim. So we really want to work with people, especially when they have federal housing supports, if they have Section 8 or public housing, we really want to do all that we can to try to keep survivors housed safely. Because once you lose that benefit, it's very hard to reestablish affordable housing and housing safety with the federal government. So with evictions, the landlord or PHA may evict a survivor if they can demonstrate actual and imminent threat to other tenants or the employee of the property. The threat must consist of physical danger that occurs in real time. And the eviction should really not occur if there's no other action that would reduce or eliminate the threat. We also know as people working in this field, as advocates in this field, we know there are ways to get survivors safe. And we do have shelters. Often they're very crowded and it's hard to get access to shelters, but it is important that if there is a way we can get survivors safe to mitigate threats or safety threats so a survivor can keep their housing, that's something also people working with survivors should be thinking of. We really are hoping that a survivor losing their housing as a result of the violence or harm that someone else is doing, that is a very, very last resort, and we support them as much as possible in our communities to prevent them from losing their housing. So lastly, there is a confidentiality clause, and we want to keep survivors' information in strict confidence. We know that there's so much danger in a community, a housing community, that would put a survivor into danger if they're coming forward to people in their community, to their housing authority, to a federal housing agency. We want this information to stay confidential, and housing providers should not be letting any and all employees within an agency or housing department have access to this confidential information. So we know some of our basic confidentiality tenets is that we really think this information should be consented to by the survivor and be time limited, and that there should be confidentiality at the forefront when we're working with survivors on trying to keep them safe and implementing the VAWA housing rights. So that's a very quick overview of just like the 101 of our VAWA housing protections. I'm going to pass it over to Kate Walls of the National Housing Law Project, who has a whole wealth of expertise in this area as well. So I'm passing it to you, Kate. Thank you.
Thanks, Steve Fox. So I'm going to talk about documentation. This is probably one of the most common areas that housing providers subject to VAWA get wrong, that they tell a survivor, you have to have an order of protection, you have to have a less than 30-day-old police report, you have to have other evidence before I'm going to honor your VAWA housing rights. However, the way the statute is created, it says that the survivor gets to decide the type of documentation they provide to their housing provider, or if they're an applicant to housing, the same is true to that program that they're applying to for assistance. They can submit the HUD VAWA self-certification form, which is called HUD Form 5382. This is a self-certification under penalty of perjury. They're providing a short couple paragraphs, if that, statement as to their status. They do not have to attach anything to that. Or if they feel comfortable with it, they can provide police, court, or administrative records, a statement from a third party, which can be a victim service provider, medical professional, mental health professional, or an attorney. Both are signing that under penalty of perjury. Or at the housing provider's discretion, other evidence. So this could be emails or text messages or voicemails or social media postings from the perpetrator showing evidence of the violence. Next slide, please. So the landlord is free to take the tenant's word. Oftentimes what we do when we're talking to housing providers is to say, you probably have witnessed some of this, right? Someone has come into your management office and they have a black eye. Someone from your security team witnessed the physical abuse. You went in to inspect the home, you saw damage to a door or a wall. You asked what it was, and the person told you that it was as a result of domestic violence. You can accept that as a housing provider, document it in the file, and leave it at that, and then honor their VAWA housing rights. Or you can ask the tenant or applicant to prove the violence. Any request, however, must be in writing, and the tenant or applicant has to be given 14 business days from the request in writing to provide proof. The housing provider is also free to grant any extension of time if the tenant needs more time, and we strongly encourage that they do. But as I said, the survivor gets to choose the documentation type. So generally, we encourage the completion of that HUD VAWA certification form. It's not really the provider's business as to all of the details of what a person has experienced. So we think this is the safest option for the survivor. The only exception to this is where there's conflicting evidence. And what conflicting evidence means in this case is that there are two parties coming forward accusing the other of being the primary aggressor. And then in that case, the housing provider can ask for third-party documentation, like a police report, an order of protection, etc. This is not an opportunity for the housing provider to say, I just don't believe you. So that's the conflicting evidence, and I need you to submit third-party documentation. That's not how it works. That's not what HUD has said is permissible. It has to actually be two parties with conflicting evidence. Next slide, please. Emergency transfers, many survivors, even to this day, are in subsidized housing, but they are unsafe. And so we always say that the predicament that they're in is they have to choose between their safety and their housing subsidy. So in VAWA 2013, there was language added to require housing providers to have an emergency transfer plan that would allow survivors to move if they are unsafe or in the event of a sexual assault even if there's no future risk of harm, to move within 90 days of the sexual assault occurring on the premises. So providers have to have an emergency transfer plan. Currently, HUD encourages but does not require them to make it public. So you may have to ask for it. I encourage you, if you're a victim service provider in the community, to ask for it. The same type of documentation requirements that I talked about apply. Providers are encouraged to cover moving costs, but they're not required to. Providers could also offer an admissions preference to other survivors who live in other housing. And a lot of victim service providers in various communities have encouraged housing providers to do that. Partnerships are key here to make transfers work. So really to be working with victim service providers, legal aid, housing providers, HUD offices, to really come up with a transfer plan that works in the community and that centers the choices and the needs of survivors. Vouchers could also be a transfer option. So getting a housing choice voucher from a public housing authority is possible. The housing authority has to put it into their administrative plan in order for that to be allowed. Next slide, please. So there are many updates from VAWA 2022. I'll just go through a few. First, prior to VAWA 2022, if your VAWA rights were violated, other than raising those issues in, let's say, eviction court as an offense to an eviction court proceeding, there was no what's called express private right of action. You couldn't easily go into federal court and sue your housing provider for violating your VAWA housing rights. So as part of the 2022 reauthorization, there is now a process for survivors to file what's called HUD, Office of Fair Housing and Equal Opportunity Complaints. The link that's put in the slide gives you the information on that complaint process. I'm happy to talk to anybody who thinks that their clients may need to consider that. There is also protection for everyone, whether or not you're a survivor of gender-based violence, to, thank you for the 5-minute warning, to be protected in your right to report crime or seek emergency assistance. If the locality that you live in, that local city or town, has any type of program or policy, often called a nuisance ordinance or crime-free ordinance, that penalizes you or others for calling the police for help, 603 bars that if that locality is receiving community development block grant funding. As well, sexual assault survivors can be served with homelessness assistance funds regardless now of where the incident occurred, and they don't have to be fleeing physical violence in the home. And then finally, tenants and program participants who exercise their VAWA rights are protected from retaliation and interference by a landlord. Interference could include a landlord saying, I'm not honoring your VAWA housing rights. I don't apply them here. And that is unfortunately a real example. Next slide, please. There is also now, we're very excited about this, a new gender-based violence prevention office within HUD that includes a VAWA housing director. The director of gender-based violence prevention equity has the name, that's Carlo Ng, who is my predecessor at the Law Project. We're still waiting for the VAWA director to be hired. They have a large coordination role within HUD and the other federal agencies. Just 2 weeks ago, they issued an interagency letter on the baseline of VAWA housing protection. So across all the federal agencies operating programs subject to VAWA. Next slide. And then we've got a range of materials and resources that you're welcome to peruse. And I am also a TTA provider, happy to provide assistance when it comes to determining what VAWA housing rights your clients may have. Thank you.
Perfect. Thank you, Kate. We're just going to go through each of the materials and resources and just have them on the screen just quickly before Tiara begins.
Yeah, so there's brochures that we have. We have information on safe housing tools. The VAWA brochures on the HUD landing page for VAWA come in 13 different languages, so be sure to check that out. NHLP has a VAWA brochure that's in more simplified language for survivors in English and Spanish. Next slide, please. Then we have the HUD VAWA self-certification form that comes in 15 different languages, and what's called the notice of occupancy rights. Briefly, housing providers are obligated to issue a notice of occupancy rights to all individuals, regardless of their survivor status, at admission, admission denial, termination of assistance, and eviction. Next slide. Again, additional research page for the ACLU, National Housing Law Project, National Alliance for Safe Housing, National Domestic Violence Hotline, National Law Center on Homelessness and Poverty, the Network to End Domestic Violence for DFOXes, and many others. Just to note out on this page, increasingly states and local housing and localities provide housing protections for survivors. We just updated the compendium. So this is now, the title is incorrect. This is now the Housing Rights of Domestic Violence and Sexual Assault Survivors, and is covering since, let's see, March of 2024, all the state and local protections for survivors of gender-based violence as it relates to housing.
All right, perfect. Next, we have Tiara joining us.
Great. Thank you so much, Anna. And good afternoon, everyone. I'm Tiara Williams, and I serve as the Virginia Services Training Officer and Prosecution, or VSTOP, and Virginia Sexual and Domestic Violence Victim Fund Grant Program Coordinator for the Victim Services section at the Virginia Department of Criminal Justice Services, or DCJS. I also serve on the board of directors for the Association of VAWA Administrators, better known as AVA. And as indicated on the AVA website, the mission of AVA is to encourage and facilitate mutual support and awareness and cooperation among states and territories administering VAWA formula grants, and to provide a centralized voice for the advancement of improvements to enhance the effectiveness of VAWA administration. And I truly appreciate the opportunity to be a part of this forum and to provide information from the perspective of state administering agencies. You all have received access to such great information thus far. I do apologize in advance. I am going to go off camera during my overview. My camera tends to lag or kind of hiccups my connection during prolonged use, but I will turn it back on during the designated Q&A time, so I appreciate your patience with that as well. Today, I will be covering general information and doing more like just information sharing as opposed to training. I aim to provide insight on my role as a staff member at a state administering agency on today, and I hope that it's helpful in aiding you all in navigating the grant application process for STOP formula grants within your respective states and territories as well. The slides have been shared with our host today for you all to be able to have access to the content as well as the links available. And so thank you all so much again for your attention to this information. So I'm just going to go ahead and just give you just a quick overview of our content for today. Again, this is just an agenda, and as the program coordinator, I'll be sharing with you just information regarding the VSTOP grant program here at DCJS, as well as information on our role as the state administering agency and insight on how we assess grant applications at the state level, for the STOP formula grant program. So I'll start with some background information on this funding source. In 1994, the United States Congress passed the Violence Against Women Act, or VAWA, as you all have heard about a great deal. And it was part of the Violent Crime Control and Law Enforcement Act. And one part of VAWA is the Stop or Services Training Officers and Prosecution Formula Grant Program. And so within this grant program, it is administered by the Office on Violence Against Women, or OVW, as previously referenced. And the STOP program actually promotes a coordinated, multidisciplinary approach to improving the criminal justice system's response to violent crimes against women. It also encourages the development and strengthening of effective law enforcement and prosecution strategies to address violent crimes against women. And then also STOP prioritizes the development and strengthening of victim services in cases involving violent crimes against women. So here in Virginia, DCJS implements the STOP grant program. And within victim services, which is the section that I work under, we are responsible for the day-to-day coordination of the STOP formula grant here in Virginia, along with other grants as well. So our team also develops trainings. We provide technical assistance to our subrecipients within the Commonwealth of Virginia. We implement statewide initiatives. We develop best practice resource materials. We draft and review policies, and we support victim serving organizations throughout the Commonwealth of Virginia. So just a little bit about what we do in a nutshell. And then our victim services staff is also responsible in assisting individuals and communities impacted by mass casualty events through our victim assistance emergency response, which is known as our VCART team, which I also serve on our crisis response team as well within the state. Currently within the victim services section at DCJS, we administer 6 grant programs that support projects within victim service organizations throughout the Commonwealth of Virginia. So that includes both federally funded as well as state funded victim service initiatives. Within Virginia, we refer to our STOP formula grant as VSTOP, and it reflects the program requirements indicated by VAWA, but also it's guided by our VSTOP state implementation team, which every state and territory that administers a STOP formula grant is responsible for having a state implementation team. Currently within Virginia, there are 85 projects funded by VSTOP across all applicable categories, and I'll mention those categories a little bit later within the overview. So as previously mentioned, the STOP of this particular grant program is to enhance the capacity of local communities to develop and strengthen effective law enforcement and prosecution strategies to combat violent crimes against women, and to develop and assist and strengthen victim services in cases involving violent crimes against women. So grant funds must be used to address one or more purpose areas pursuant to OVW. All program goals and objectives must be consistent with one of the purpose areas as well. And the purpose areas are typically found within the grant guidelines, funding opportunities, requests for funding, or solicitations, whatever your state calls that, their particular guidance for applying for a grant. The purpose areas are typically reflected within that document as well. So in Virginia, as well as in most states, the STOP formula grant is open to local units of government, state agencies, and nonprofit or non-governmental victim services agencies or courts, which fall into one of the following categories, and that's law enforcement, prosecution, victim services, courts, and discretionary. And similar to other funding sources, programs must not only meet the eligibility requirements to apply for these funds, but they also must propose funding for eligible items and projects within the funding source. So STOP funds can be used to fund positions in law enforcement, prosecutors, system-based advocate, legal services, counseling services, training initiatives. It can also fund sexual assault forensic examinations and collaboration efforts to focus on improving the criminal justice system's response to violent crimes against women. However, STOP funds cannot be used to pay for promotional items, criminal defense work, exclusively serving victims that are younger than the age of 11, purchasing vehicles, renovations, or even construction. So the list that I just gave, it's not all inclusive for allowables or unallowables, but I just wanted to highlight some of those allowable and unallowable costs because we often receive inquiries about them, whether it's during the application phase or even once we are in grant tracking and projects have been awarded and have been implemented. But information on allowable costs as well as priorities for funding and eligibility requirements for your STOP grant can definitely be notified with, well, shared, excuse me, within the funding opportunity language, or you can contact the state administering agency for your state to obtain additional information on eligibility and allowability as well. So here are current funding percentages for the categories that I previously mentioned under STOP. And adherence to these funding percentages is actually a requirement of the federal award from OVW. So these are actually determined by our federal partners. Excuse me. I apologize for that. So now we're going to transition into the bulk of my information, and that's exactly what does a state administering agency do? So SAAs, as I also may refer to them as, are organizations that receive direct awards or funds from our federal partners such as OVW. So we ourselves are recipients of federal awards. Each year we apply for these funds via an application process. And within my role, I essentially serve as a liaison between OVW and DCJS. And as the state administering agency, it's our responsibility to develop and implement a process to appropriately distribute the federal funds to provide allowable services based on the priorities that have been set forth by our federal partners. So within STOP, it was created for the purpose of enhancing the capacity of local communities to develop and strengthen their responses to violent crimes against women. And so all funding powers, however, do rely with the United States Congress. And once the federal awards have been determined and accepted by state administering agencies such as myself, we then have additional autonomy to determine additional priorities and allocations of the funds as well. So as the STOP coordinator, I work to not only coordinate our state and federal funding streams, but I also assist our internal staff in managing and monitoring our subrecipients once they have successfully received an award from us. So I'm responsible for developing and soliciting applicants for funding. I implement criminal justice system policies, procedures, and practices. We address the needs of victims and collaborate with stakeholders to optimize victim services within the Commonwealth. And then we also work within our internal staff to develop trainings and resources to promote the success for not only our applicants, but also our subrecipients once they're managing their grants and implementing their federally funded projects. So this is done through a multitude of methods ranging from electronic resource dissemination. We host on-site monitoring visits where we physically come to our funded programs and we get to see the great work that they're doing, boots on the ground. We also provide technical assistance and support, as was previously shared by our other presenters here today. We also host webinars on a wide range of topics ranging from effectively completing a grant application to budget modifications, all the way to trauma-informed services. So we do a lot to meet the needs of our subrecipients as well as our applicants on the front end for those folks who have not yet received a grant from DCJS. So I'll now provide some information on the grant application and review process for those of you who may be considering applying for a STOP formula grant in the future. Now, these are very essential elements of the work that I do as a grant program coordinator. And I hope that by hearing from my perspective, you'll become a little more familiar with what we look for at state administering agencies. Again, I only represent one perspective. I did receive some input from my peers in other states in preparation for today. But again, this is general information, but I do hope that it is definitely helpful in promoting your success in applying for a STOP formula grant. So before I provide insight on key tenets to consider when writing a grant, I did want to just take a brief moment to inform you all of the review process here in Virginia. And we pretty much have that process spelled out on the screen before you in a nutshell. This process is consistent with processes completed in other states. I have actually been afforded the opportunity to serve on grant reviews with my peers in other states who administer stop formula grants. And so here in Virginia, as well as in other states, some of our elements of our process look very, very similar. However, your state administering agency can provide you with concrete details on the review process. And a lot of times we will try to include that within the grant application process as well, or the grant guidelines, excuse me. So here in Virginia, following receipt of an application, we conduct a comprehensive review based on the grant guidelines. So again, that's your framework. The grant guidelines truly provide you with all of the necessary information that you need for successfully completing your application. So once the application is received, we conduct that preliminary review to determine if the applicant is eligible. And so we talked about eligibility earlier within the overview. And then we also assess the application to determine if the proposed project is allowable under the purpose areas pursuant to OVW. So if the eligibility as well as the allowability, excuse me, criteria are met, then we will go ahead and proceed with conducting a review. If it is not met, then we will withdraw the application and written notice will be received by the subrecipient. Excuse me, by the applicant, I apologize. So all eligible applications are receiving a comprehensive review by not only our internal staff at DCJS, but we also contract and consult with external non-DCJS reviewers to have an unbiased review process as well. And the reviewers will assess each application based on the information that is provided. So we only take what's provided in the application for face value. We also look at the applicant's adherence to the grant guidelines, as well as the clarity and the substance and the strength of the request for funding. So the reviewers can also take into consideration things such as the demonstrated need. We look at the geographic location of the proposed project, your justifications that are provided with each of the items, the cost effectiveness of proposed projects, and as well as the availability of funds to be able to support these projects. So it's very important for me to mention that as the state administering agency, we do reserve the right, even in our review, to strike out requests at any given time that may not be allowable. So you may have a very strong proposal, but there are some items that are unallowable. So we may do that as well within our review. And we will notate that within our review form because we also have a review form that we follow to provide comments and insights on scoring. So then after we've conducted the review, we provide a list of programmatic as well as budgetary recommendations to the Criminal Justice Services Board, which is the governing body at DCJS. So within our agency, as well as many other state administering agencies, the final recommendations and final approval for funding does not lie solely with the program coordinator, such as myself or even my manager, but we actually have a governing body that provides final approval for awards. And so they provide their recommendations for funding based on the information that we provide in our review sheets when we are scoring each of our applications. So then once we've gone through this process, the applications are awarded, and that is notified. All of our applicants are notified via a press release. And in Virginia, we also allow our applicants to request their review forms after applications have been awarded as well. And a lot of our applicants, I apologize. A lot of our applicants appreciate that opportunity to obtain their review sheets because if they were not awarded, it provides them with information on how to enhance their application the next go round or areas that could have been approved. So that's another offer that we have as well to promote future applicants' success in applying for our awards as well. So I can imagine you're thinking about how you'll know about the new funding opportunities, and I also wanted to touch base on that today as well. So when funding becomes available for new initiatives here at DCJS, we make every effort to ensure that all eligible entities are aware of the funding opportunity. We definitely like to boost up our number of applicants. And so we do this by posting the solicitations on our agency's website. We also have a mass listserv called DCJS Updates that the community can apply, can register for, our subrecipients can register for, stakeholders can register for. And we actually send out information about training opportunities, resources, upcoming events, as well as funding opportunities. They are all disseminated through this mass mailing known as DCJS Updates. We also ensure that we send these to all of our state partners and other state agencies to share with their listservs as well. We also make announcements at any meetings in which we are in attendance at, whether at the state level or at the local level. And then we also request that we have this featured within our newsletter within Victim Services. We actually have a quarterly newsletter. We also have a podcast that we host called Dialed In with DCJS, and we notify all of our listeners about funding opportunities via that forum as well. And then we also host what is called a quarterly conversation for all of our subrecipients, and we notify them of our funding opportunities also, whether they are for new applicants or if they are continuation opportunities. So we definitely do our due diligence of trying to cover all bases, whether it's through electronic dissemination or sharing it, verbally via a web-based or in-person platform. We definitely want to make sure that we are notifying the masses of our funding opportunities. And that's another thing that our federal partners actually expect us to provide them with information on when we complete that implementation plan that I had referenced earlier. So we are also held accountable by OVW to ensure that we are doing our due diligence and ensuring that all of our folks know about our funding opportunities as well. So I just want to go over some key factors for grant writing, just to keep you all mindful of some things to be some things that can help you in promoting your grant writing as well. So within Virginia, we do our due diligence to ensure that all of our grant funds are equitably distributed. And so with that, we also want to make sure that we have the resources readily available for folks to promote their success in writing grants. So I will definitely say just some tidbits that I want to share with you all in this forum that I think that regardless of what state or territory you're applying for funding in, it will definitely be helpful to you as well. So you definitely want to ensure that you are providing a very concrete justification for any items. You definitely want to make sure that you review the grant guidelines in their entirety to assess your eligibility. You also want to make sure that you have adequate staffing, resources, and supports to implement the proposed grant project. You also want to make sure that you have the infrastructure for a sound financial and programmatic capacity to be able to implement and effectively manage the federal funds that you are in receipt of. We also want to make sure that our subrecipients have diversified their funding streams so that they're not solely reliant on this one particular funding source. So again, I strongly encourage you to review the grant guidelines, assess your eligibility, but also make sure that within your particular organization, you are confident in your capacity to not only apply for this grant, but to also effectively manage the award as well. I will say that within our funding opportunities, we support programs by also sometimes offering a pre-award questionnaire or a readiness assessment that covers a lot of different areas in which you will have to assess your capacity to effectively manage a federal or state grant. We also, within your applications, as we're conducting our reviews, we also look to make sure that you are requesting the maximum amount that you're allowed to or less than that. So you're not exceeding your allowable amount. We're also looking to ensure that certifications are signed by the appropriate authorized individuals. We also look at your budgets to make sure that they're thorough, that they are you're proposing allowable items, all of the items are allocable, they're appropriately justified, and that they include a basis of computation as well. And one of the things that I always teach our reviewers, but that I also encourage our applicants when I do the application training, is that you want to provide exceptional details within your application, as many of our reviewers may be unfamiliar with not only your organization, but also the great work that you're doing. So you want to write your grant as if you're writing it to someone who has no idea about the project that you're proposing or the great work that your agency anticipates doing. So I definitely want to also highlight that little nugget as well. So before I close out, I definitely also want to just highlight that the importance of not only understanding the requirements of not only the application, but also the grant that you could potentially receive. You want to be sure that you have all the measures in place to be able to demonstrate good stewardship over these funds. For programs that have significant risk, we try to work extensively with them to mitigate any risk once they become a subrecipient. And so we'll work with you through technical assistance and support to mitigate risk so that you continue to receive the funds to do the great work that you are funded to do. And so I definitely do like to share this slide as well, even when we're conducting our applications, about again, we front load the information so you know what you're getting into essentially for the grant, but also understanding that you want to be a strong subrecipient as well, not just have a strong application, but prepare to be a strong subrecipient to continue to receive these federal funds. And that also is our responsibility as the state administering agency. So just a little bit on technical assistance. The presenters prior to me have provided great information on how phenomenal technical assistance can be. And we also provide that at the state level as well as the state administering agency. And it can take various forms from Zoom calls, on-site visits. We actually also host office hours solely for applicants during application time. We also provide application trainings that are either live or recorded. We also provide resources. So we do a multitude of things to be able to support our programs in application time as well through technical assistance and support. And so your state administering agency is the best source of information at application time. I've provided very general information here today, but on the screen before you, I do have links that include directories to every single state and territory's stop administering agency, and it'll provide the direct contact for the stop administrator and or coordinator. They use the terms interchangeably. And so AVA has a directory as well as OVW. And here are just some additional resources that we have actually referred our subrecipients to. During technical assistance, we cannot write your grant for you. However, we can provide you with information on allowable costs. We can provide you with information on determining eligibility. But these resources on the screen before you, we have actually referred some of our subs to for that really deep dive into effectively writing a grant for federal funding. And so again, you all will have access to these slides and these links to be able to do a little more digging. And of course, as always, you can attend the trainings and opportunities offered by your state administering agency. So I want to thank you all so much for your time and attention in this overview today. If you have any questions about the content that I've shared, please feel free to reach out to me via email or phone call. But if you have application-specific questions, I encourage you to contact your state administering agency, and I'll turn it back over to our host. Thank you.
Thank you so much, Tiara. That was incredible. Unfortunately, to the lack of time that we have left, we are going to have to skip the Q&A today. But luckily, all of our lovely panelists will have their emails on the next slide. So if you have any further questions, you're able to contact them directly via email. Thank you so much to all of our wonderful panelists for sharing your extensive expertise with us today. Thank you to JWI's program team, Sierra, Rachel, and Alana. And finally, a huge thank you to everyone who attended this conversation today and took the time to learn something new, and to those who asked questions. We really appreciate you taking the time with us today. And if you want to continue learning with us and you haven't already, please sign up for JWI's National Alliance. We will be hosting expert-led webinars once a month on various topics related to domestic violence and sexual assault prevention and response. And lastly, please keep an eye out for a follow-up email for a survey and a video recording of this wonderful webinar today in the coming days. Thank you, everyone, and we hope to see you next time.